Good afternoon, folks. Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call. By participating in this call, we have an established attorney-client relationship. I have enough questions to cover my entire almost hour. I may have a little bit less time today, so we won't have time for new questions. That said, let me get started with first the questions I consider to be frequently asked. I have merged three of the questions into one because they all talked about notice to appear, the NTA issue. But let me begin with the first one that says, and this is a good question from Priyanka Polisetti, that says, what are the different wage levels for H-1B and green card jobs, etc.? She's actually asking about the H-1B mostly, but it is the same type of determination. The only difference between wage levels for H-1B and green cards in terms of logistics is this. When we file for an H-1, we are using our best judgment to decide which level wage will be given. When we file a green card, it is the government who decides what the wage should be. The wages are received from, in most cases, flcdatacenter.com, Foreign Labor Certification, flcdatacenter.com. And there, each occupation, based upon the county and the state in which the occupation is located, is covered under four different levels. Level 1, Level 2, Level 3, Level 4. 4 levels for every job. So for example, software developer Level 1, Level 2, Level 3, Level 4. What distinguishes the levels is the complexity of the job, the requirements that the employer has, how many years of experience, etc., and the role that is being carried, seniority level that is being carried at. Level 1 is usually for entry-level people right out of school, excuse me, doing formative jobs. So they are still learning. They have a degree, but they are still learning. Level 2 is people who are doing professional level jobs, but they are moderately complex. At level 3, you become technically advanced. At level 4, you become more advanced, but perhaps in terms of even leadership. So you may be a technical leader. If I were to give just a couple of words descriptor on each level, I would say level 1, entry level, level 2, competent, level 3, technically advanced, and level 4, technical leadership. I'm looking at Priyanka's question. She's on CPT, working as a full-time employee in Cincinnati, converting to OPT in December. They'll file for the H-1B next year. Current salary is 60 to 65K. By the way, Priyanka ji, if you convert to STEM OPT, your employer is required to pay you salary according to the prevailing wages, the FLC data center, just like we do for H-1B. That's the difference between the first year of OPT, where you could work for minimum wages, but for STEM OPT, where you're required to be paid what they would be paying you according to your seniority level. Now, you said when you looked at the wages, you couldn't tell what level you should be. So it's safe to assume that if you've been out of school 1, 2, 3 years, probably level 2 is a good goal to shoot for. But somebody who has relatively less experience, even level 1 could be okay. But USCIS creates issues, I think illegally, with level 1 salaries saying that, well, this job doesn't look like it's that complex. You probably don't need a degree for this job. So you get into that. Of course, people are winning. We are winning cases, even at level 1, where there's a genuine level 1 job description and the job is clearly a professional position, what they call specialty occupation, that needs a degree. We are able to win those cases. But it's definitely another data point to watch out for. So I don't know what level you are working at, but your lawyers will be able to help you once they look at your job description when you file for H-1B. Anyone has a follow-up question on what I just talked about, press *5 on your phone, please. Any follow-up questions, press *5 on your phone. Okay, so we've got one so far. *5 if you have a follow-up question. And this one is from Ohio. So, Ohio, go ahead, please.
Hi, Rajesh. I'm Priyanka.
Yes, ma'am.
So I come under the entry-level job, and I have graduated recently. I mean, I would be graduating in December, and then would be converting to OPT then. So so I was just wondering if having a pay between 60 to 65 would cause any issues for H-1B.
Did you look at the entry-level job for your category? What was the wage on that?
So I just know the job description is related to our entry level.
Okay, hang on one second. You see, when you go to the FLC data center, they have certain job titles. So you have to select the applicable job title. What do you do, ma'am?
I'm a .NET developer. It's a software developer role.
So chances are you will go with software developer level 1 wage. Now, that can be problematic. Your lawyers will help you decide, but the exact amount of the wages depends upon the county, the state, and the job description along with the job title. If I were you, I would shoot for level 2 software developer at least.
Okay. Yeah. So, just wondering if this will create an issue at the time of H-1B or
It can. Definitely it can. Because like I said, at level 1, government often comes back and says, well, not really a professional job, not that complicated. They are wrong. They are losing or they are backing off in a lot of these cases, but there are cases where they're denying.
Okay.
Good luck, ma'am.
Yeah. Thank you.
You're welcome.
Thank you.
Anyone else has a follow-up question on this? No new questions. *5, please. Folks who are just joining us, I just want to remind everyone, I will not have time for new questions today. Let's go on to the next, actually very concerning topic. Oh, no, that one is coming after that. So the next question is travel outside the USA when a case is pending. Rick has asked a question that's narrowly tailored to his case, but I wanted to address this issue in a larger context. Normally, when you leave the United States when a case is pending, you have filed a case. That case, completely or in part, it is considered to have been abandoned. So if you leave USA while a case is pending, that case, depending upon the case, is considered to have been abandoned partly or completely. Let me explain. Let's talk about first completely. So when you have a 485 pending and you leave the USA without an H1, L1, H4, L2 visa or advance parole, your 485 is deemed to have been abandoned. A B2 extension, tourist visa, or a B1 extension, if it is pending and you leave the USA, you are deemed to have abandoned. How about H1 extension? No, you haven't abandoned your H1 extension if you leave the USA. It's the same for amendment. So in cases of H-1B extension, amendment, or transfer, leaving the USA and coming back while it is going on or right after it is approved is okay. A case of part denial is when you have applied for example, F1 to H1. Now, when you apply for F1 to H1, you ask for two things. You say, Mr. Government, declare that I'm entitled to an H1. I won the lottery, my job qualifies, the salary qualifies. So the government makes one determination that you are entitled to an H1. That H1 needs to be actually physically given to you, what is called change of status. So you are on F1. To change status to H1, you have two options. Either you get a change of status within the United States, which is normally the the box we check on the forms that we file for you, or you can go outside USA, get a visa stamping and come back. So once again, two processes in the H1. One is asking for H1 determination and second one is the change of status. If you leave the United States, when you have filed the case F1 to H1, it's still pending. Half of the case is deemed to be abandoned, or I would say part of the case. So if the H1 is approved, by leaving, you have abandoned your request for change of status. So that means you are now going to have to go get a visa stamping before you can come back. So this is an example of part abandonment. Even in the 485 context, by leaving, if you have a 485 pending without an advance parole, without an H1L1, H4L2 type visa, you haven't abandoned your green card. You have just abandoned your 485. If you came back again on an H1 and the dates were current, you could refile your 485. Or you can convert your green card to consular processing. So you're not abandoning your whole case. That's the way it works. Now, Rick said, I moved from client A to client B in June. Employer filed an amendment. I think you mean transfer. I moved from client A to client B. My employer, okay, so it's a client, end client. Oh, I see. Sorry, my misunderstanding. So you're moving from end client A to end client B. Employer filed an amendment to show that that's what you're doing. Your current H1 is good till September 2020 when you are with client A, but your visa stamping expired last year. Can I travel while my H1B amendment is pending? Yes, you can. As my visa got expired, I have to get it stamped again, correct. Do I have to go to the interview or can I do by Dropbox? I don't know the exact local rules, but you have to go for visa stamping, that we know. I don't remember all the rules on that. You should not go until the amendment is actually approved. That would be my take on your situation. *5 if you have any follow-up questions on what I just discussed. *5. Okay, I've got one question. Anybody else has a question? Press *5. Any follow-up questions? No new questions, please. Give me 1 second. So this is from Minnesota. We have a question from Minnesota. Minnesota, go ahead, please.
Hi, Rajiv. I'm Rick. This is my question.
Yes, sir.
So probably I understood that we can travel outside the U.S. when H-1B amendment is pending.
Right.
But we cannot go to stamping until the H-1B amendment is approved, right?
That would be my recommendation. Although legally speaking, you have an H1, you can still go for a stamping. But I don't think the consulate will give it to you. They would be well within their rights to insist that you wait till the amendment is approved.
Oh, okay. Okay.
All right.
So if I go for stamping, I should go on the new H1.
Correct. That is correct. Yes, sir.
Okay.
All right.
Okay.
Good luck.
Thank you.
Mm-hmm. Okay, so the next frequently asked question, these are one after another. Now this one is an important one, folks. I have talked about this several times. I have even recorded some videos, audios on this, and you can find them on my blog on immigration.com. Also, if you go to immigration.com homepage and look at the top right, those are all our social media contacts. You can find this article about NTAs also on, in addition to my blog on immigration.com, my Facebook page, my LinkedIn page, as well as a Google+. Am I forgetting? Yeah, I also post links on our Twitter account. So any of these places you can go to read these articles in detail. Yesterday, or was it day before yesterday? Maybe it was day before yesterday. Government announced that they were postponing the NTA memorandum. So the details of the NTA memo, what it means, I have discussed several times in many calls. I won't go over them again. For now, most of the NTA questions are redundant. The NTA memorandum has not been implemented. However, the 3 people who had posted questions related to NTA, I merged their questions into one And I'll address their situation specifically, simply because even though the NTA is not implemented yet, it probably will be implemented eventually. April Wilson says, under new deportation and denial policy, if I want to renew my green card after 10 years, well, first of all, April, so far, green card renewals have been pretty much an administrative process. It's like renewing your driver's license. They don't really have you go through any extensive hoops. If your green card is denied due to a minor admin error, can you be deported? Look, even under the NTA, if they put you in deportation, your lawyers can walk over the evidence of the error either to the court, if the court is already taking your application, or even to the USCIS ICE lawyers in this case, and explain to them why this case should be dropped and your status should be corrected. So minor errors, I think, would be corrected. Right now, there is no NTA, there is no problem. But even if it gets implemented, chances also are that as and when the NTA policy gets implemented, it would be more reasonable than the way they had announced. It appears to me as though Steve Miller, that ogre in the White House, along with your Trump, they sit down and they dream up all these crazy schemes, not realizing how the law and process works. All they want is to hurt people, immigrant, whether they are legally here or undocumented. That's all I see in these policies. I really don't see any reason to announce these types of policy except to make things difficult for people who are trying to stay in the United States, whether it is legally or undocumented. So they announced this policy probably not realizing how much more complicated it is than just writing a memorandum and throwing it out. They have gone back to the table probably to figure this out. The same thing happened with H4 EADs. They stood up in open court and said, well, we are going to take away the H4 EAD program. And by the time they decided, they realized that it wasn't really that easy. There was a lot of homework to be done. It's definitely become a problem for them because they have to issue new regulations to overrule the H4 EAD regulations. So they were supposed to have done this in July, or was it June? I think it was in June they had said they will take away the regulations, but now we are in August. So far, good for us, good for everyone that they have not been able to give superseding regulations. NTAs are sort of going the same route. Government tried to announce this really crazy policy, but they realized this was much more difficult to implement than they thought. And I think they would be sued many times over because there's something fundamentally wrong in the way they are approaching this. Do they have the power to do that? Probably yes, but not through a memorandum. Even to implement something as draconian as an NTA, if it is legal, it has to be done with regulations. Because to me, it's a violation of the Administrative Procedures Act to implement a change in a long-standing policy without issuing regulations on that. So policies, when they are long-standing, they should be overruled or changed by regulation, not with a memorandum. Okay, so if 10-year green card renewal is denied, that's what April says. If my 10-year green card renewal is denied, but I have 1-year green card stamped on my passport, see, you are posing a question that really is so far out of anybody's experience that I would really decline to even consider that hypothetical, because until we confront it in the environment in which it is posed, because the environment of the laws will change, in the environment in which it is posed, only then I will be able to answer that question. In today's environment, all of these questions really don't have any meaning because none of this is likely to come to pass. If they want to take away somebody's green card, they can't just refuse to renew it. They have to take you to immigration court, put you through deportation, try to invalidate your green card. It isn't that simple. Green cards can be revoked if they are obtained through 485 within 5 years of approval with a notice. After 5 years, it can only be done with immigration courts. And you should be able to keep working in your sort of situation, I believe. And again, there are so many of these questions that really, let's talk again if it ever comes to pass, April. I don't think you can plan for it. And I frankly don't think any of this is gonna happen. For I-90 form, I don't need to submit minor traffic tickets. I do not know if they ask for any of that. You need that for N400s, but like I said, renewal of a green card is an administrative process so far. What extra document submission is recommended for 10-year green card renewal? Same answer right now. It is just very basic. As far as I remember, I haven't filled a Form I-90 in decades. Our office takes care of all that. But I don't think it's something that you need to prepare extensively for. So anyone has a question so far, press *5. I'll go on to other NTA issues posed by other two people who had posted. So, okay, I've got one question out of New York. Yeah, New York, go ahead, please.
Hey, Raju, thanks for your explanation. This is regarding the green card denial you were explaining. In case if the green card is denial at any cost, whether it's a renewal or during N400 process, whatever it is, when it goes to immigration court, how many years, we have time to leave this country, or how many days we have to leave this country, Raju?
Typically, when a case goes to immigration court, it begins by the filing of a notice to appear. Right now, the immigration courts are so backed up, 700,000 cases pending in a backlog. So you probably are looking at a 2 to 4 year period, maybe even more, depending upon where you are. Now, if you wanted to leave earlier, your lawyers can always ask for voluntary departure or try to organize it with the government's lawyers to make it easier for you to leave. But time-wise, it's a matter of years, not months.
Thank you.
You're welcome. Okay, let's go on to the next part of the NTA questions. I don't recall who had posted this from our community. This one is about H-1B extension pending, I-94 expired, also applied for H4 plus EAD with a future start date. So if the H-1B is denied, it'll create a gap. Am I prone to the NTA? So between the time you posted this question and now, the NTA has been put on hold. So these questions really don't mean much. If the NTA memorandum comes back, we will have a call discussing all these issues. But right now, there is no NTA memorandum. You can let it go. *5 if you have a follow-up question. *5. Okay. And the last question in the NTA series was, enrolled in second master's and CPT. Now, CPT went over 12 months. H1 got processed in the lottery. What are the chances to have a successful change of status from F1 to H1? Look, if the government gives you more OPT than you're entitled to, they'll consider you to be out of status. Worst case scenario, you have to go outside USA for visa stamping. They'll not deny your H-1B because there's a problem with the CPT. Unless there is some kind of active fraud or misrepresentation on your part, your H-1 will be approved, but you'll be asked to go get your visa stamping from outside the USA. Okay? And there is no NTA for now. *5 if you have a follow-up question on this. *5. Okay, so I think the first three questions were all they were all frequently asked questions. I don't believe we have any other frequently asked question. Let me just go over so we're going to get started now with our regular questions. And the first one of those is from SHD. When my employer applied for my green card, title was programmer, green card was applied for manager. After getting the green card, within how many days should I change the title to manager? And the answer is commercially reasonable period. What that is, nobody knows. I would say certainly the best I can guess for you is within 6 months or so after the green card approval. How long should I stay with the sponsored employer? We have a bunch of videos on that and frequently asked questions on immigration.com. You can take a look at those. I'll summarize for you. When the green card is approved, the date your 485 is approved, you should have the permanent intention to stay with this employer. Permanent doesn't mean forever. It simply means that you had no end in mind to the job when the green card was approved, when the 485 was approved. If a few weeks later or a few months later you got a better job offer or a different city that you liked, I think you'll be okay taking it. *5 if you have a follow-up question on this. *5. Okay, this one is also New York. Yeah, New York, go ahead, please.
Hi, Raju. I stayed with my the green sponsor employer for 2 years, and after I moved the company and as a developer because my green card was applied for engineer, but now as joined as a developer because of the good pay. So does it matter when I'm applying N4?
It doesn't matter at all. You were there 2 years.
And,
that's more than enough.
2 years is more than enough. And during the promotion from my programmer to manager, do I need to change the wage, or it can be the same wage as, because he was paying me as the manager's salary when I was a programmer?
I don't see.
So
there's no change necessary, because under the law they are only required to offer you the wage that they put down in the labor certification, the POM application.
And the title, it has to be same as the I-140, or it can be matched with any other title in the company?
Well, that depends. That's something you should be discussing with your lawyers, not with me. They should look at your paperwork. Typically, if it was prior to January 17th, which is what your case was, prior to January 17, 2017, when Supplement J had not come out yet, you could take, after the 485 had been pending 180 days, pretty much any same or similar title in the company. Now it's a little bit different. Now you have to have a Supplement J filed. In your case, I think even a same or similar title would be okay. But please talk to your lawyers about it. Okay?
Thanks.
You're welcome. Okay, let's go on to the next one. From Manglesh, CPT for more than 1 year. I need to file H1 extension. If I file my H1 after August 20, I will be unlawful presence after August 10. Well, the problem here is with the memorandum about the student status, government had given some odd interpretations, and I don't remember the exact wording, that you could be unlawfully present if you have violated your status. Look, in any of these situations, I'm inclined to be very, very conservative. I don't like to take a chance. Definitely talk with your lawyers. See if you need to go outside USA and come back. Okay, that's something I would recommend as a cure for this issue. *5 if you have a follow-up question. *5. See, normally what happens is when you step outside USA and come back, status issues are resolved unless there is some kind of an active misrepresentation or fraud against you. Again, allegation against you. Okay, let's go on to the next question. From Akshay, friend came to USA on F1 visa several years ago. She worked illegally. Even though there's no record of this employment, she did work illegally. And in many of the subsequent documents filed with the government, she has said that she did not violate her status, which is not true. So the situation is this. Now, to put this in generic terms, you have a situation where you're about to file your 485, but in your past, you have either concealed or misrepresented certain information, like having violated your status by working without authorization. How do you fix this? It's a difficult situation, because By not telling the truth about the past untruths, you are perpetuating a lie. By telling the truth, you are exposing yourself to a permanent bar from entering the USA. If I were the lawyer, I would have to advise them to come clean, let the government know what happened. My only argument would be that not all misrepresentations are fatal to your case, and a misrepresentation that has no significant impact on the possible outcome of the case can be considered to be an immaterial misrepresentation. So that is the only direction I can see myself going. I think you have to tell the truth, whatever the truth is. And if it becomes a permanent bar, so be it. But I don't think you can continue to hide this situation. Star 5, if you have a follow-up question. Okay. So once again, yeah, it's a permanent bar. If you have ever either procured or attempted to procure an immigration benefit through fraud or misrepresentation, you are permanently barred from entering USA. But what if the misrepresentation is about something that's not even material? So that's the only ground I can think of, along with the fact that you are voluntarily submitting this information to the government. You might be okay. I think it's something I would not like to comment on until I've spent a few minutes going over the documents, thinking over what is the best way forward. But that would be my first reaction to a situation like this. Next question is about having received some benefits from the government. So if you Google public charge space uscis.gov, public charge space uscis.gov, you'll come to a page that tells you, in order for us to decide whom to allow into the USA and whom not, we are going to look at the totality of circumstances. But if you have received cash money from the government to bolster your income, or are receiving long-term medical care, we think you're going to get denied. But if you have not received, and I think that page actually mentions the program that you talked about, I think it was SNAP program. That SNAP program is expressly excluded from the list of things that are bad for you. Go take a look at that page. I think it'll make things a lot clearer for you. Trump administration has been trying to make it a lot more difficult and a lot more complicated for people. So far, they have not implemented those regulations, even though public charge regulations were proposed, but then they have been put on ice for whatever reason, I don't know. But in the proposed regulations, their approach to receiving public assistance was a lot tougher than the current approach, which is about cash assistance or long-term medical care. But of course, they are still looking at totality of the circumstances. Star 5 if you have a follow-up question. And yeah, you should correct your 485. You can contact your lawyers. You can contact USCIS customer service. Let them know that you want to correct it. Make a note of the date and time of your call, whom you spoke with. So yeah, you have to correct your 485. Okay, next question. Do I need to disclose my traffic tickets with no points and less than $500 fines in N400? And the answer is, I don't know. I can't help you fill forms. However, just read the instructions on the forms. Whatever they say, follow them. If in doubt, err on the side of too much disclosure rather than too little. In addition, remember, none of these traffic tickets, unless there are just too many of them, are actually going to be a problem for you to get your naturalization. Star 5 if you have a follow-up question. Star 5. Okay. Also New York. Wow, it's guys, try not to post more than one question, because I see like 5 questions from the same guy. Because our team stops stops the posting of questions about 18 or 19 questions. So if one person is asking 4 or 5 questions, it takes away from other people's opportunity. Try to just restrict it to 1. Go ahead, sir.
Rajiv, I am asking a follow-up question from the other person's question. Actually, it's not from my question when you answered. This one related to the traffic tickets. You mentioned, do we need to include the parking tickets also in the naturalization, or
tickets are not relevant? No, I don't think parking tickets have any relevance, because parking tickets are not really, they're not moving violations. They're not really indicative of you as any kind of a threat to the government, to the safety of the public or property of people in the United States. So I can't think of anything that parking tickets would be. Of course, if you had 300 parking tickets that you haven't paid, that could be a different issue. But if you received 5, 10, 15 parking tickets, or even 50 parking tickets in 5 years, I don't think that's a problem.
Even not moving violation traffic tickets, the records they could not found like 15 years ago. So if you
still mention it, I would put it in a letter, and I would say that I tried to get, but I haven't been able to obtain the records, and I would give them concrete dates and times that I tried to contact the government, and this is what they told me.
Okay, sure. Thanks, Raji. I'm sorry, because I was asking the follow-up question from the other people's question. I'm sorry, but thank you.
It's all good. It's all good. Okay. Then we go on to New Hope 13. Obtained my green card through EB2 at the end of April 2018. Started working for this employer a year ago. It's been 3 months since I've had the green card, leaving my current employer and to work for myself in the same field. I already answered this question once today, but I'll answer it again real briefly. What is most important is, on the date you received your green card approval, you had no intention of leaving. If after a few months, even 3 months, you have changed your mind and you want to work for yourself, I think you are okay. There is no magic number on how long you should stay. But 6 months or so is a good idea. Less than 6 months, it's okay. If you got a good lucrative offer and there's a reason you're doing it, you want to start your own company, something like that could be a good reason as well. You can wait a couple of months more, sure, that's also a good idea. I think it's very difficult for them to take away green cards from people like you, because the real crux of the matter is, on the date you got your green card, what was your intention? Okay. *5 if you have a follow-up question on this. *5. H-1B F2 help. I'm an Indian citizen. My current H-1B first term employer filed Chapter 11 bankruptcy. Less than 24 hours notice. 60-day grace period ends on August 28th. My husband is an F1 student. If I change to F2, can I switch back to H-1B? Yes, you can. Do I have to go through the lottery again? No, you won't. Not until 6 years have passed from the date of your H1. So if you got your H1 in 2010, up until 2016, you're not going to be subject to the quota again. Assuming, of course, that you got your H1 through a non-quota, through a commercial employer, a quota employer. Okay, so you can convert to F2 and convert back to H1. *5 if you have a follow-up question. *5. All right. So let's see where you are located. You are, I guess your voice over IP, I don't know where you are. Give me 1 second. It bothers me when I can't figure things out. Oh yeah. Sorry, you are in Pennsylvania. I was voice over IP. Okay. So Pennsylvania, go ahead. We can hear you, please.
Hi. So this is actually posted by my wife, and the question is, since we posted this, she actually got a job. She has an offer pending.
Great.
So the question is now that August 20th is coming up, and the Vermont Center F2 transfers are 11 to 14 months. What is the best, the route of action that we should take? Should we just go ahead with F2 as a backup?
See,
And if we do go that route, how can we switch?
Okay, hang on. Is the employer applying for her H1 right now?
No, we still have to accept the offer. This happened yesterday, so they will. We will ask for H1 through premium processing.
You have two options. One option is, because even if she gets an H1, if it comes after her H1 status is gone and F2 is pending, they are going to ask her to leave USA to get a visa stamping. So you have two choices. Either send her for an F2 visa stamping now, which is at best unknowable. What are the chances? Who knows? Or second choice is to send her for an H1B visa stamping when her H1 petition is approved. Why does she need the stamping? Because she would not be in status. She would just have an F2 pending by the time her H1 is decided. So in either case, whether she applies for F2 or H1, it looks like she's headed outside USA. Okay.
Okay, but so if we do the premium processing, we still have till August 28th, right? So if she gets her receipt and starts working, and then the visa, the H1 transfer goes through, or if it gets denied, like what are the options?
I think if the H1 is filed within the 60-day grace period, I have some doubts. I have looked at the regulation many times, and I'm not sure the regulation is worded very clearly. It seems to imply that you can start working, but there is some possibility of an interpretation that says you shouldn't be working until the H1B is approved. But let's say when the regulation is confusing, we can take the interpretation that's most suitable for us until the government decides to go in another direction. Now let's assume that's the case. If that is the case, if her H1B is approved, it will be approved within the USA. She will not have to leave. You can withdraw her F2. Okay.
Okay, and then if it is denied, and if we haven't filed for F2 right now,
then the F2 is still pending, right? So she should be okay.
Okay, so you suggest we should go ahead with the F2 anyway?
You haven't filed it yet? You're still thinking about it?
No, we're waiting for the I-20 from the university.
Okay. Well, I think you should discuss. I'm a little uncomfortable because I don't know exactly what the timelines, etc. are. Talk with her lawyers what they suggest, but I don't think filing an F2 is such a bad idea.
Okay, thank you.
Okay, good luck.
Thank you.
Okay, so we've got that covered. Now, Pandu says, my H1 extension is approved until 2020, including my dependents. I-94s are good till 2020. We have an EAD, green card EAD, good till Jan 2019. Filed I-485 under EB1 category, I-140 approved, congratulations. Got green card EAD AP, waiting for 485 interview and approval. My role has changed. Immigration team filed for H1 amendment. Got an RFE. H1 has been denied. What would be my situation? What options I have? Well, first of all, you should plan on being outside USA if your status is expired. But your H1B can be refiled premium processing, or an appeal can be filed. Appeal takes too long. In most of these types of cases, I would probably refile the H1. Oh, wait a minute. You've got your advanced parole and EAD. Sorry, I lost that for a moment there. If you have your green card EAD and advanced parole, you can always work on your EAD. So scratch that. You don't have to be outside USA. You have your green card I-485 and EAD, I-485 pending, EAD approved. You can just switch to EAD. Now, eventually get your H1. but keep it in your back pocket to be activated through visa stamping only as and when convenient or necessary. So you can get the H1 approval, keep it pending, keep working on EAD. Whenever you have the time or you need to get your H1B visa, you can go outside USA and get it stamped. Okay. Star 5 if you have a follow-up question. And of course, there is no impact on your wife or children either, because they have their own 485 spending, right? So they should be okay. Star 5. All right. So the H1B denial doesn't affect any of you because of your 485. Unless there is some connection between the denial and your green card. Animesh says, I'm a technical project manager, but employer filed you as a systems analyst. Well, I'm not sure this situation would worry me, because I don't like employers to state anything but the exact truth. So if you were working as a manager and you're getting paid a lot more money, that's what they should have put down on your H-1B paperwork. You should talk with your lawyers, see what they recommend, and they should talk with your employer. This record needs to be straightened out. Star 5 if you have a follow-up question. Star 5. Okay, SK 2008, 2 questions related to EAD AP. I started my green card with company A and received EAD AP in 2012. Never used EAD. Moved to company B using H1B transfer. This H1 is good till August 2019, but the visa has expired. Last year I went outside and came to USA on advance parole. Well, it looks like you're on advance parole. I have to look at the regulations. This used to be a matter of just a memorandum about entering back on advance parole. I think it has been encoded in the regulations that came out on January 17th, 2017. So I have to look at the regulations, but my guess is you are on advance parole, authorized period of stay, not on H1. You can, of course, get an H1 visa stamping after H1 approval and come back on H1. You are back on H1 status then. You cannot travel if your EAD renewal is pending. The government considers that to be a withdrawal or abandonment of your advance parole. Star 5 if you have a follow-up question. Okay. Next question is from Ganesh 10. Lost job when the company downsized. I've got about 1 month left on my 60 days. Spouse is on F1. If I file H1B to F2 within the grace period, can I stay lawfully? Yes. You would be an authorized period of stay. Well, there's a follow-up question. Let's take that first. Now, folks, be a little quicker about the follow-up questions, okay? This one is from Connecticut. Okay, Connecticut, go ahead, please.
Hi, sir. My name is Satish. I have a follow-up question on the EAD, advance parole.
Sure.
So, if I want to renew my EAD and advance parole, like how soon I need to file my application?
I think
Is it 120 days or 180 days?
I think it's 180 days from January 17th onwards. All the new regulations changed a bunch of things. One of them was to allow you to apply 180 days ahead of time.
Okay, sir.
All right.
All right, thank you, sir.
Oh, you're welcome. Okay, let's go on to... This is Ganesh 10, of course. Company downsized, 30 days left on H1B grace period. Spouse is on F1. If I file to F2, so it used to be that was considered to be authorized period of stay. But with the NTA memorandum, if that comes back, my answers would have to change. Right now, I don't see any problem in filing for F2 and hanging out. And again, as I answered just a few minutes ago, if your H-1B is filed within 60 days grace period, then you are fine anyway. Okay. Star 5 if you have a follow-up question. If you are here, I can answer any other questions you have. Star 5. Okay. Well, I've already covered this ground before earlier, and I think I've answered your questions as well. Raghu wants to know if I should apply for naturalization with my wife. Well, what I'm doing these days is that if a husband and wife comes to me and let's say the green card was obtained based upon the wife's application through her employment, and both of you got your green cards through that application, she was the primary in the green card, I would have whoever was the derivative, which is you, the male member of the couple or the husband, you file it first, get your naturalization, then let your wife file. Simply because in your application, there's going to be a lot fewer issues than in the employment-based main applicant's application. So if you have a couple, I would have the derivative beneficiary apply first. Star 5 if you have a follow-up question. Okay, this one is area code 217. There's a follow-up question. And that's Illinois. Illinois, go ahead, please.
Hi, Raju. Thank you for the opportunity. I'm wondering if I can ask this as a follow-up question or ask it later. So, I'm a green card holder and I got my green card from work. Okay, now my fiance is she's not based in the United States. So I was wondering, what is the best way forward for that as far as, do I wait to naturalize?
Totally unrelated question, and I'm not taking new questions today. But since you are already here, and it's a matter of love, let's see if we can address something for you. See, as a green card holder, you don't have too many choices. You can, of course, get married to her and apply for her green card, and it'll take whatever time it takes according to the country of birth. But that's not really a great option, but that's the only one you've got. Now, on her own, she could come on H-1B, L-1B type visas, and of course, you can be married before or after she comes. But there are not too many options as a green card holder. As a citizen, you would have K1, K3 options, but not as a green card holder.
Yeah.
Okay?
Yes. Okay. And she can't come just to visit,
well,
and then
she can, but if she's coming to visit her fiance who's a green card holder, they'll probably turn her back at the airport. They can. And if she
but if she's able to come visit,
if she doesn't disclose that she's coming to, I have had cases where somebody said, well, I just told them I've come to visit. And I said, that doesn't sound like the truth. Because if your fiance is in USA, you're probably coming just to visit them. And tourism, if there is any, is incidental to that visit. I would be uncomfortable advising people that's the truth. So tell the truth. If they turn you back at the airport, so be it. If they don't, great, you're able to come and visit.
Okay. Thank you, sir. I appreciate the answer. Thank you very much.
Good luck. Now, Santosh 321 says, I'm on H-1B through employer A, working at the client location for 3.5 years. They have a full-time position with better pay. My current H-1B I-94 expires 2018 September. Employer A has already applied for extension. Can employer B apply for change of employer? Yes, they can. Definitely. I have a bachelor's and master's in non-computer science, expecting an RFE or a denial. I'm planning to leave if it's denied, then come back on H4. My wife is also on H-1B. Will my prior H-1B denial affect the H-4 visa stamping? No. That kind of thing can happen only if there is some misrepresentation or something that disqualifies you for the H4 on a more general basis. So no, it shouldn't be a problem. *5 if you have a follow-up question. *5. Okay. And the last question for today is Samir Arora. I'm on H-1B with employer A, completed first 6 years of my H-1 and my I-140 is approved. Wife got her H4 EAD. She's currently working full-time. Employer A filed for extension of H1 as well as H4 EAD, got approved until June 2019. Last week, employer B filed for H1 transfer, got approved till 2021. The H4 visa also has the same validity. So what you mean is not visa, but H4 for your wife. B wants to restart my green card. So I-140 will be approved again. I might not be left with enough time to apply for my wife's H4 EAD. See, if your old I-140 is not revoked by the employer for 180 days, then your wife can get her H4 EAD based upon the old I-140, whether it is revoked or not revoked, as long as it stayed unrevoked for 180 days. So that is definitely an option. Those are the two questions you had. *5 if you have a follow-up question. Okay, there are 3 hands raised right now. One of them is the same person, it looks like, at least it's the same company. So I'm not going to answer your question. You can put your hand down. You had like 4 or 5 questions already. So you can press *5 and take yourself out of the race. That leaves me 3 people with their hands up. No new questions, only follow-ups, please. Let's deal with them one question at a time. So I'm going to skip the New York. All right. Then the next one is New Jersey. All right. Now this one is area code 352. Area code 352. That's Florida. Area code 352, Florida.
Hi Rajiv. Actually, this is a follow-up question for the previous question. I'm the person who posted. This is Santosh.
Okay.
So I have one question. So like once I go for a H4 stamping and once it's approved, I'm planning to come back on H4 and complete my master's in computer science and then again go back on H1. Is that transition possible, like from H1 to H4 and then back to H1?
Absolutely, I think so. Definitely. Okay.
Okay. Yeah, thank you.
You're welcome. All right, so that leaves me with 2 more questions. One is Samir. Yeah, go ahead, Samir.
Hey Rajiv, this is Samir. So I posted that question, the last one.
Right.
I mean, I've already joined the new employer. So you're saying that the old employer cannot revoke the 140 for another 180 days, right?
No, that's not what I said. Let's just focus on your case instead of a generic legal statement. When was your I-140 approved, approximately?
To 2015, March 2015.
So that means you're already safe because they never revoked your I-140, right?
I mean, I switched jobs last week, so I was with them until last week, right?
So that means your I-140 stayed approved for more than 180 days. Out of
more than 2 years.
Out of which at least 1 day was past January 17th, 2017. In that case, your wife is entitled to H4 EAD extension and you to H1 extensions based upon the old I-140. Even if they revoke it. Even if they revoke it. Okay.
So I just have to give the alien number, right, for the next extension, or do I need?
It'll be nice to have a copy of the I-140 approval, but even with an A number, they should be able to get it done.
Okay, because I don't have the copy of approved I-140. The employers don't generally share it, but I got all the documentation from FOIA, right?
And they did not,
so I have all the
FOIA
documentation.
didn't give you a copy of the I-140 approval?
I don't see the approval there. They have the entire documentation and then they have the A number, right? They generally send a CD with a PDF file in it.
With the A number should be enough.
Oh, okay. And so when my new company starts my green card process again, they'll have to start from the labor application, right? Or can we do directly I-140?
You have to go to the labor cert first.
Okay. Okay.
All right.
Okay. Okay. And one last question, Rajiv. So say for example, the H4 EAD is under renewal process. Documentations have been sent to USCIS. Can the H4 person travel out of the country or no?
They can. They shouldn't travel. Check on the rules on the EAD, traveling while the EAD extension is pending. Last time I checked, they allowed you to do that, but they said it could delay your EAD application. She will of course need an H4 visa stamping. So the answer is she can travel. What impact it has on a pending EAD application should be examined once again, but traveling is not an issue as long as she knows she'll have to get a visa stamping.
Okay.
Good luck.
Thank you so much, Rajiv. Thank you. Yeah.
Last question is from New Jersey. New Jersey, go ahead, please. 7-3.
Hello, sir. This is Raghu.
Yes, Raghu, go ahead.
This is regarding the N400 application.
Right.
My application, in any case, if it denies, if got the green card on H4 basis, so later on if she applies, is there any impact for my wife or son? So just wanted to know.
I'm not sure I understand your question, Raghu.
Actually, no, I got the green card, and if I apply for N400 citizenship, and if my case got denied, if my wife applies later after denial,
okay, let's back that up a little. Okay, first of all, it depends upon why the N400 is being denied. If the N400 is denied on some basis which puts into jeopardy your green card approval, then she's got a problem as well, because her green card was derivative upon yours. If your green card goes away, so does hers. There's no question of naturalization. If, on the other hand, your naturalization is denied because of some personal conduct, you have some kind of a conviction or some other issue which doesn't affect your green card, in that case, her naturalization does not get affected.
Okay. That answered my question.
Good luck.
Thank you very much, sir.
Folks, it's good talking with all of you. My time is done today. We'll talk again in a couple of weeks. As always, it's a pleasure and a delight to hang out with all of you. See you in 2 weeks. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.